Good evening, ladies and gentlemen. Greetings from Bangkok, Thailand. Welcome all of you to the launch webinar of the UNODC Handbook on Restorative Justice Programs. And good evening for Thailand, but for those of you who are joining us from different time zones, good morning and good afternoon, wherever you are. I'm delighted to welcome all of you. We are launching the UNODC Handbook, of course, developed by the UNODC in collaboration with the Thailand Institute of Justice, the TIJ. My name is Wongthep Achakaivanvati. I am the special advisor of the TIJ, and I will be the moderator for this session. And first, let me express our sincere thanks to the UNODC for initiating this launch webinar. And of course, this is something that we at the TIJ fully support. You know, this week is quite special. It would have been the week of the UN Crime Commission in Vienna. But of course, we know that we have to adapt ourselves to the current situation that we are in. But I am glad that we are still able to launch the handbook within this week. So this is very good. And to tell you also about the objective of the webinar is not only to promote, of course, we're promoting the UNODC handbook, but I think this is a good opportunity for us to discuss and to engage in a conversation about the importance of restorative justice. And I welcome all stakeholders, you know, governments, academia, people from practitioners. Okay, I think this is a very important issue because we think that restorative justice not only, important not only within the framework of the criminal justice system, but also even beyond the realm of justice. I mean, really encapsulates the importance of the link between the rule of law and sustainable development. And I also see this as the way of promoting a counter prevention in our society. And that is something that certainly enhances the access to justice and community resilience. So I think this is very timely. And of course, I'm very excited that we are going to be discussing this. We're going to be sharing good practices and experience, including some of the common challenges that we're facing in the implementation of restorative justice in different parts of the world. Before we begin, I have some announcement in terms of the technicality for this webinar. First, let me inform you that the webinar will be recorded and that it will be made available online after the webinar is over. So that's one. Second, the participants are invited to pose the questions using the Q&A box, okay, on the screen. Participants also encouraged to further engage in a conversation via social media platforms like Twitter, you know, using the hashtag RJ Handbook Launch, okay, RJ Handbook Launch altogether, okay. I would also like to inform you that the handbook itself is accessible on the UNODC website. So you can actually go to tools and publications, and under alternatives to imprisonment and prison reform, that's where the text of the handbook is located. Lastly, particularly for Thai participants, the TIJ has also arranged for English-Thai simultaneous interpretation for you too. So you can just click on the interpretation button at the bottom of the screen. All right, so the total duration of the webinar will be 60 minutes, and each panelist will be given about 7 minutes for your presentation. The discussion will start with the introduction of the handbook, to be followed by presentations by 3 distinguished members of the panel, whom I will introduce shortly. And after that, we'll probably have about 20 minutes left for the Q&A session. Now, before we start, I have a pleasure of inviting Professor Dr. Kittipong Kittiyarak, the Executive Director of the TIJ, the Thailand Institute of Justice, to give his welcome remarks for the launch webinar. Please, Dr. Kittipong, the floor is yours.
Thank you very much, Kun Bongtep. Good morning, good afternoon, good evening to all participants all around the world. A warm greeting from Bangkok, Thailand. I am Kittipong Kittiyarak, the Executive Director of the Thailand Institute of Justice, or TIJ. On behalf of TIJ, it is my great honor to be here to launch the second edition of the Handbook on Restorative Justice Program. I welcome all of you virtually to this webinar. I would like to first thank the United Nations Office on Drug and Crime, or UNODC, for the excellent collaboration in developing this innovative and much needed tool. I also would like to extend my gratitude to all the experts who participate in the expert meeting group held in Bangkok in June last year. This handbook represents a joint effort in many ways, and I hope that it will help pave a harmonious path toward wide-scale criminal justice reform in the near future. Over a decade ago, in 2006, the first edition of the Handbook on Restorative Justice Programs was published by UNODC. Since then, restorative justice, or harmonious justice, or Yutitham Samanchan, as it is more commonly known in Thailand, has become increasingly recognized as an important measure to enhance the rule of law and access to justice. Its participatory nature offers a way for victims, offenders, and the community to participate in the resolution of a crime, also with the help of a facilitator. The end result is an agreement that redresses the suffering of the victims while supporting the reintegration of both victim and offenders. In addition, restorative justice can be an effective preventive measures in helping to divert court cases. It prevents and reduces offenders from entering the prison system. As you know, prison overcrowding has been a source of great concern, not only from the perspective of justice, but also those of human rights and health. And especially in light of the COVID-19 pandemic, the dangers of prison overcrowding are very clear and present. If this has already triggered a policy rethink in many countries toward non-custodial measures, for example, I feel that restorative justice too should be further promoted more widely. And for this reason, I think the launch of this handbook cannot be timelier. The handbook covers a wide range of topics, including good practices for program design and implementation, the mobilization of community assets, as well as program monitoring and evaluation techniques. To support countries in advancing restorative practices, this handbook also presents information and examples that will be useful in the development of new programs in a variety of social, cultural, and legal contexts. Ladies and gentlemen, today launch webinar makes a new beginning of a rewarding partnership. Multi-stakeholder collaboration, I believe, will be vital in transforming this fruitful knowledge into impactful action. We need to work together to disseminate the handbook widely. We need to strengthen capacity building activities. Above all, we need a momentum. We should turn to stakeholders, criminal justice practitioners, policy makers, civil society, academia, volunteers, and the media to help raise awareness on restorative justice. The Thailand Institute of Justice is honored to be part of this movement and will remain committed in the journey toward advancing criminal justice reform, both locally and internationally. I would like to close my remark by reiterating my thanks to the UNODC and all the experts who contribute substantively to finalize this handbook, which will go a long way to enhance the implementation of restorative justice program worldwide. Against the backdrop of the new normal, I also encourage us to think about how restorative justice can contribute to the SDGs and how innovation plays a role in this regard. After all, restorative justice breeds social harmony and community resilience, and we should all take necessary steps to realize that common vision of ours. Thank you very much. Back to you, Kun Wongthep.
Thank you very much, Dr. Kittipong, for your inspirational remarks, actually, which really nicely set the tone of our conversation going forward. I understand that you may not be able to stay on, so we thank you for being with us now during the opening session. Thank you again, Dr. Kittipong. Now, I would like to start with the introduction of the handbook by Ms. Jamie Lee, Crime Prevention and Criminal Justice Officer of the Justice Section, the UNODC in Vienna. Jamie focuses on promoting restorative justice and effective use of alternative to imprisonment. Prior to that, she worked as an attorney at the nonprofit in New York called Sanctuary for Families, where Jamie represented victims in human trafficking and family-related cases. Jamie holds a JD from Columbia Law School. Okay, that is by way of introduction. Jamie, the floor is yours.
Thank you, Wongthep. And thank you to all those around the world who could join us in the launch event today. I hope that you're all safe and healthy in your homes. It's a real pleasure to introduce the handbook on behalf of UNODC. Like Wongthep said, my name is G.A. Lee, and I'm a Crime Prevention and Criminal Justice Officer at the Justice Section of UNODC, where I focus on promoting the use of restorative justice and also alternatives to imprisonment. And for the next few minutes, I would like to share a bit of information about the background to the development of the handbook, and to also give you a glimpse of what is new in the second edition and set the stage for the upcoming interventions from my co-panelists. As Dr. Kittipong has mentioned, the proper use of restorative justice that gives an opportunity to all those affected by crime, including victims, the offender, their families, and community members, to collectively address the harm that has resulted from it, is an essential strategy to widening access to justice and a key component in achieving the Sustainable Development Goal 16 on promoting peaceful and inclusive societies and providing access to justice for all. The revised handbook is the newest addition to the UNODC's Criminal Justice Handbook series, which is a collection of more than 60 guidance materials in the area of, in various areas relating to crime prevention and criminal justice. And developing technical guidance materials such as this is one of 3 core areas of our work, in addition to supporting the development of normative instruments and providing technical assistance to criminal justice reform to requesting member states. As mentioned, the first edition of the handbook was developed nearly 15 years ago, in 2006, to provide practical guidance on the subject following the adoption of the basic principles on the use of restorative justice programs in criminal matters by the Economic and Social Council back in 2002. But as you know, the field has gone through an enormous and significant development and expansion since then, both in terms of the number of countries that use it and the scope of their use. Because of these developments, in 2016, member states requested UNODC to canvass the use of restorative justice around the world and to convene a meeting of experts to review exactly how it was being used and to examine the new developments and innovative approaches in the field. So throughout 2017, UNODC collected information on the use of restorative justice, and this exercise revealed that there was such a great increase in the development and use of restorative justice programs around the world. But it was also observed that it still remains underused in many regions, and that greater awareness needed to be raised about its benefits and proper use. And these issues and more were further discussed at a meeting of restorative justice experts in Ottawa, hosted jointly with the Government of Canada in November 2017. And here the experts noted that the basic principles was a useful framework for setting the minimum standards in using restorative justice, but that the field has gone through so much development and sophistication that there was a need for further practical guidance on various aspects relating to restorative justice. And these recommendations then led to member states' specific requests to UNODC in 2018 to update the Handbook on Restorative Justice Programs through a resolution adopted by the Commission on Crime Prevention and Criminal Justice, which is the UN's main policy-making body on criminal justice issues. And with this mandate, UNODC prepared an updated draft, and it was reviewed at an expert group meeting held in Bangkok, hosted jointly with the government of Thailand, where more than 30 experts from all regions of the world participated in their personal capacity to share their views, experiences, and research. And it is through this review and validation process that really contributed to making the revised draft as comprehensive and updated as possible, with many new research findings and national examples. So I'd like to take this opportunity to thank each and every expert who was involved in this review process. In terms of what is new in the second edition, in addition to updating the information in the first edition, there were also many areas that reflects the developments in the field since. And these additions were primarily guided by the conclusions and recommendations from the expert group meeting held in Canada. Specifically, we took note of the experts' observation that there was now a much more nuanced understanding of restorative justice than there had been in the early 2000s. So the new handbook provides a more in-depth explanation on the key concepts contained in the basic principles, along with an updated overview of the types of programs that exist around the world. It also contains a chapter on restorative justice responses to serious crime, which was not so prevalent back in the early 2000s. And this chapter provides guidance on implementing the fundamental procedural safeguards and lays out the common concerns that have been identified by experts in this area. It also covers a range of specific factors to consider for different types of serious crime, such as intimate partner violence and sexual violence. And for the practitioners in the field of restorative justice, the handbook also has a chapter dedicated to what requirements there are for successful operation of restorative justice programs, including the promotion of referrals, on safe and meaningful engagement of victims, on preparation of participants, facilitation of the processes, and partnerships with the support services and the community. There is also a chapter dedicated to program monitoring and evaluation with updated research findings, which may be very helpful for practitioners and academics. A lot of this updated and new information is also accompanied by national examples to illustrate the sheer diversity in implementation around the world. The handbook is designed to be used by all actors of the criminal justice system, and it can be used in a variety of contexts, either as a reference document or a training tool. And with the new handbook, UNODC will now step up its efforts to provide technical assistance to requesting member states, including through support in legislative reform, policy advice, and in building the capacity of criminal justice actors. And in this regard, I would like to draw your attention to the fact that we're in the middle of developing a training curriculum in this area, and I would like to ask you to tune in for the development of that. This concludes the introduction of the handbook, and I hope that is a useful resource to all of you. I'd like to once again thank the Thailand Institute of Justice and Justice Canada for their excellent cooperation towards the development of the handbook that made it possible. And thank you very much for listening. Back to you, Vangthat.
Thank you very much, Jamie, for that introduction. Very useful. It gives us the background of how the second edition of handbook came about, and you certainly touch upon some of the important aspects. But one in which I would like to really highlight is the fact you mentioned about the need for a more of the public awareness of this issue. I think this is something that is relevant in many countries, not just, certainly it's the case in Thailand, but this is something that we need to continue the momentum towards, and of course, some of the new areas that you mentioned, particularly, reference, a stronger emphasis on serious crime. Very good. So that is something that we have now set the stage for the further discussion, and which is why I am pleased to introduce our first panelist, Professor Yvonne Dundurand, Fellow and Senior Associate at the International Center for Criminal Law Reform and Criminal Justice Policy, the ICCLR, based in Vancouver, Canada. And Yvonne is also a Professor Emeritus, a Professor of Criminology at the University of Fraser Valley. He specialized in comparative criminal justice research and has been extensively involved in a number of justice reform development initiatives in many countries. And he is also one of the main drafters of the UNODC handbook on RJ programs, both the original one and this one that we are launching now. So Yvonne's topic for presentation is enabling the national roadmap for restorative justice. Yvonne, you have the floor.
Thank you, Vongtep, and thank you to all participants for joining us today. As Dr. Kittipong mentioned, a lot of progress has made in the last 20 years or so or less since the adoption of the UN Basic Principles on restorative justice. Some states have tried to expand the use of restorative justice and make it available at every stage of the justice process. However, few countries have managed to provide comprehensive restorative justice programs on a national scale for both adults and children and for most types of offenses. Progress, I would say, has been relatively slow, certainly slower than expected. In fact, existing initiatives rarely achieve the level of public acceptance and support required for their broad-scale implementation. In the meantime, criminal justice resources continue to be channeled towards traditional criminal justice responses to crime. Let me use the next few minutes to talk about the institutionalization of restorative justice in criminal matters and the role that national strategies can play in that process. Internationally, the institutionalization of restorative justice has taken many different paths. There's a broad range of definitions and applications of the concept of restorative justice. Restorative justice intersects to varying degrees and in different ways with the criminal justice process. And that intersection occurs at various stages of the criminal justice process. And as a result, programs have adopted many different forms. The published literature on restorative justice programs sometimes fails to convey the vast differences that exist around the world in the application of restorative justice principles, practices in criminal matters. Among other things, cultural differences, variation in criminal justice practices and traditions, and the political aspects of justice reforms are insufficiently acknowledged. As you will recall, the 2002 Basic Principles recommended that states should consider the formulation of national strategies and policies aimed at the development of restorative justice and the promotion of a culture favorable to the use of restorative justice among law enforcement, judicial, and social authorities, as well as in communities. The Basic Principles also recommended the adoption of national guidelines. However, in my experience, very few countries have actually given themselves such guidelines or national strategies, let alone develop a roadmap for the systematic implementation of restorative justice principle throughout the criminal justice system and beyond. Hopefully, every country can be encouraged to do so. One positive development over the last decade or so has been the growing number of rigorous evaluations of restorative justice programs. These evaluations have helped us understand the benefits of restorative justice approaches and programs. As most of you already know, these many benefits include wider access to justice, more effective resolution of conflicts, greater victim satisfaction, and in some cases, therapeutic impact for victims, greater likelihood of offenders' desistance from crime and successful social reintegration, and very importantly, greater community engagement and confidence in the justice system. At the same time, however, these same evaluations identify various recurring issues with respect to the broad implementation of restorative justice. Some of these problems come immediately to mind, and most of you are already familiar with them. They include low level of referrals to programs, hesitation or resistance on the part of justice and allied professionals to use restorative justice, victims' difficulty in accessing restorative justice, community resistance and the need for greater public awareness and support, difficulties in linking restorative justice program to other essential services and protections for both victims and victims, issues relating to the governance and especially the funding of programs, the need for specific guidance for police, prosecution, volunteers, and others involved, and the need for adequate training for facilitators and professionals. Too often, it seems countries rely solely on legislation permitting the use or authorizing the use of restorative justice services, on broad policy statements, on general guidelines promoting the use of restorative justice, without really addressing issues such as those that I just listed. No one should be surprised, therefore, that with such limited initiative, restorative justice is failing to grow deeper roots within the crime prevention and justice. These initiatives too often fail to develop, as the basic principles recommend, a culture favorable to the use of restorative justice. In some instances, they promote restorative justice as a type of diversion program for minor crimes and first-time offenders, but fail to convince or incentivize the system to consider diversion seriously. In other instances, the programs that are promoted are primarily offender-oriented, and victims' participation remain limited. In most instances, they encourage the development of programs, but fail to fund and resource them adequately. I would suggest to you that there are no effective shortcuts when it comes to developing and implementing a national restorative justice strategy. The process, I would suggest, starts with a good review and understanding of existing criminal justice practices and how they can incorporate restorative justice. It continues with building on early successes and building on existing institutional and community strengths. It requires a long-term commitment to the initiative and the marshalling of adequate resources. As it happens, this is what the Thailand Institute of Justice is trying to accomplish through a research project that is now nearing completion. In Thailand, the concept of restorative justice or harmonious justice has been applied since the early 2000s. The country has experienced both progress as well as drawbacks in its efforts to mainstream restorative justice into existing criminal justice processes. A wide range of interesting practices have emerged throughout the country over that period, reflecting different circumstances and different interpretations of the law. The time came to take stock of these nearly 20 years of experience and to map out a path for the wider and deeper implementation of restorative justice throughout the country. So TIJ agreed to lead that process. It started with a national symposium last year, followed by a national consultation with key justice officials, and the launching of a study on the state of restorative justice. The study involved a review of the legislative framework and interviews with victims of crime, facilitators of restorative justice processes, and justice officials from all four main regions of the country. The study is reaching its final stage, and its findings should be released shortly. Without prejudging of its findings, it is fair to say that the study is likely to offer a roadmap for the consolidation of existing programs, and the further integration of restorative justice practices throughout the Thai justice system. I look forward perhaps to another TIJ webinar, hopefully soon, during which the study and the resulting roadmap will be presented. Roadmap will probably address some key implementation challenges and will include practical measures to improve victims' participation, to further integrate restorative justice programs in the juvenile justice sector and in the rehabilitation and social rehabilitation sectors, and to concretely explore the application of restorative justice in matters involving more serious crime. It should also contain suggestions concerning the consolidation and strengthening of relevant legislation, as well as some general directions concerning capacity development and the training of officials and facilitators. I hope that together all of today's presentations and Handbook will encourage countries to learn from each other's experience and to proceed more strategically to improve the use of restorative justice. Thank you for listening. Over to you, Vanka.
Okay, thank you very much, Yvonne, for your presentation. You certainly walked us through, some of the important concepts of RJ and how it started. And thank you for also mentioning the work that also the TIJ is doing. This is exactly, what we're trying to project, after some 10 plus years that RJ first initiated here, what we have learned and what kind of trajectory that we can see going forward. You highlighted a very important aspect about sort of a long-term commitment. This is key, and also the important thing, the importance of creating a conducive environment for RJ to grow, actually. And this is something that, again, pretty much tied to what Jamie also raised, which is the importance of public awareness. How do we get society to think that this is a way forward. So thank you for your presentation. Now, I am pleased to introduce our second panelist, Ms. Mary Lou Reeve, Counsel and Lead Policy Lawyer on Restorative Justice, Department of Justice, Canada. And speaking of which, I would like to acknowledge Canada's international leadership on the issue of restorative justice, as can be seen in a number of resolutions that have been adopted over decades. Actually, at the UN Crime Commission, related to RJ, since 1999, certainly the 2002 Declaration of Basic Principle on the use of RJ programs and criminal matters, but also the follow-up ones in 2016 and 2018. Canada co-hosted also the Restorative Justice Expert Group meeting, which Jamie mentioned earlier, in Ottawa in 2017. And at the follow-up expert group in Bangkok last year, Mary Lou was also a representative of Canada to that expert group, which basically finalized the handbook that we are launching now. She mainly focused on initiatives that seek to address overrepresentation of indigenous peoples and marginalized populations in criminal justice systems. Mary Lou will be speaking on a topic, challenges and lessons learned in restorative justice. Please, Mary, you have the floor.
Thank you. Thank you very much for that introduction, and I'm very honored to be joining this session with my esteemed panelists and the Thailand Institute of Justice. It was a real thrill to gather with both experts groups meetings, but particularly in Bangkok last year. And it was such a remarkable group that the UNODC gathered of restorative justice experts, practitioners, and academics. I think we all remarked on the commitment and collegiality that the group generated, which is not uncommon when people are working on a shared objective of increasing the use of restorative justice. But I am especially pleased to send greetings virtually to any of those who are watching and joining us. One of the conversations that occurred that I think was foundational at the beginning of the meeting in Bangkok was an acknowledgement that the emergence of restorative justice is in part a result of the many failures of a retributive model of justice, and that the current criminal justice system actually disempowers and re-victimizes many parties. And so what has emerged is emerged differently in countries all over the world, is the promise of a different way, a restorative process based on principles that seek to repair harm rather than to impose further harm. I'm very happy to be speaking about Canada, and as has been introduced. Thank you for the acknowledgement. Canada is a very big country, and we're very proud of the diversity and the different perspectives that are represented throughout 10 provinces and 3 territories. One of the lessons learned, I guess, in Canada, because of the size of it and the diversity, is the necessity of collaboration. And one point, or one very effective group that we have had, is a federal, provincial, territorial working group on restorative justice that has been in existence since 1997 and has united the country's work. The administration of justice is a provincial responsibility. Canada is a federation. We have a common criminal code that's applicable across the country, but the administration of justice is a provincial responsibility. So it's all the more important that we collaborate and work with the different jurisdictions. But I'm pleased to say that we do have restorative justice programs in every province and territory in Canada. And when we talk about principles and guidelines, we're also, a real accomplishment has been the writing of and adapting, based on the basic principles, the UN basic principles, but made in Canada, principles and guidelines of restorative justice that have, through the work of our working group, received the endorsement and are publicly available, but have received endorsement from the highest of justice officials, which is our ministers of justice from all of the jurisdictions. It is not difficult to talk about challenges and about restorative justice. One of our main, really significant challenges in Canada is our opportunity as well, is to listen to the Indigenous peoples of Canada to use restorative justice approaches in ways that the Indigenous communities wish to apply it. It is important in Canada to acknowledge our unique constitutional relationship with Indigenous peoples. And we have heard consistently that the principles of restorative justice are in keeping with Indigenous justice approaches to responding to harm. The legacy of colonialism has led to unacceptably high numbers of Indigenous victims and survivors and offenders involved in the criminal justice system. And it is our hope that we can build on the models that we do have, such as the Indigenous Justice Program, which is a community-led program that has been in existence across Canada for over 25 years. And it is uniquely designed to listen to the culture and the values of the community in which it is situated. And that kind of flexibility is a hallmark, of course, of the restorative process. The second challenge, and we've already heard about it, that I will mention, I know other countries experience it, but is our inability as practitioners and experts in restorative justice to explain succinctly what restorative justice is, and that it should not be considered an alternative or a diversionary only approach. Rather, that restorative justice can be complementary. It can be used with, in, or alongside existing criminal justice measures. The continued viewpoint that restorative justice is appropriate primarily for use with young persons or with respect to matters that are not considered to be serious has been one of the factors that has kept restorative justice on the margins of the criminal justice system. We know that restorative justice can be used for all types of offenses, subject to adequate supports, and very importantly, follow-up and accountability at the end of the process. Research, in fact, has shown that the more serious the harm caused, the more impactful a restorative response can be. So I'd like to conclude by echoing the comments already made about this moment in time, this unique moment in time that we are experiencing and sharing in worldwide with the pandemic. And I would like to echo the hope that has already been expressed that this time will provide an opportunity for us to consider how we respond to criminal offending and perhaps turn in a more deliberate way to holding individuals accountable based on the restorative principles of respect and dignity. So I'll end there. Thank you.
Thank you very much, Mary Lou, for your presentation. I find very interesting what you said on the regarding the concept of RJ. First and foremost, you really touch on a very important aspect that this is a there has to be an increased acknowledgement that instead of the mainstream retributive model, this is restorative justice is the alternative, but also but it's not meant to be just for diversionary measure alone, but could also be used in mainstream case. This is very important. And another important aspect, you just said it, we have to, I think all of us thinking about issues that criminal justice system are facing against the backdrop of the pandemic, what kind of thing that we can do. Is it not an opportunity for us to start thinking about perhaps now is the time to look at the possibility of promoting wider use of RJ. So this is, I think, I'm sure that we can further discuss this during the Q&A. So thank you very much, Mario. Now, last but not least, I would like to introduce our third panelist, Mr. Tim Chapman. Tim is the chair of the board of the European Forum for Restorative Justice. He is also a visiting lecturer at the University of Ulster in Northern Ireland, UK, teaching master's program in restorative practices. Tim spent 25 years working in the probation service in Northern Ireland and has published widely on restorative justice. In 2015, for example, he co-wrote a book entitled A European Model of Restorative Justice with Children and Young People, which is going to be very interesting. So Tim's presentation today, Restorative Justice in Practice, Enablers and Barriers to Sustainable Implementation. Now, Tim, the floor is yours.
Thank you very much. I bring greetings from the European Forum for Restorative Justice to all listeners to this webinar. We're a membership organization in Europe for practitioners, policymakers, and researchers in restorative justice. And they come from, I think, 46 different countries in Europe and beyond. And we have over 40 or over 60 organizations and over 360 individuals as members. So we wholeheartedly welcome the publication of the UNODC Handbook of Restorative Justice. In a relatively short document, it summarizes the current knowledge and practices of restorative justice very well. Now, while many experts from all over the world have contributed to the Handbook, we just want to express our admiration and respect for the skill and expertise that Yvonne Dondran brought to a very challenging task. Thank you very much. I also want to acknowledge that this is maybe the first time that almost the whole world is going through the same experience at the same time. I refer, of course, to the pandemic. And I hope that our shared suffering will increase, generate, and sustain solidarity internationally, and that we come out stronger from this crisis. We in Northern Ireland are in a sort of lockdown. We're meant to stay at home. And luckily, I have a garden, so I found time to do some gardening. And for some reason, at this time of suffering and death, I have almost a compulsion to plant seeds. And every day, I go down to the beds to see if there's been any growth. So I've had to learn patience and realize that some things cannot be hurried. And I want to sort of try and make that as an analogy for restorative justice. This handbook I see as a seed. Within a small space, it packs a lot of knowledge and possibility, just like a seed. Within this handbook, there is great potential for growth. But as it sits in a book, it does nothing. It must be nurtured by people. Now, I see restorative justice as also organic. It needs to be nurtured to grow. It's not a tool or a machine that you can just make and it will, produce predictable results. It's about people, it's about relationships, and it's about communication. So what does restorative justice need to grow? And this is based on our learning in Europe, and I hope it's useful to other regions in the world. 4 areas I want to just concentrate on. I think they've been mentioned already. Good policy, good public awareness, but also awareness amongst the many professionals and stakeholders that it takes to make restorative justice work. An absolute commitment to the quality of practice. There's no doubt that quality produces better outcomes. And finally, research, the importance of research. Let me start with governments and policymakers. I would ask governments and their representatives to really study this handbook and try and understand before they take any action the nature and benefits and value of restorative justice. And this will help to inform them when they decide, do we need a law? Laws can make a huge difference in terms of the accessibility of citizens to restorative justice and also to the volume of referrals. Also that they need to consider how will restorative justice be delivered in the country? Is there a need for a national coordinating body? If so, should it be a state agency or should it be an NGO? These are decisions for policymakers. And there needs to be sustainable funding. Restorative justice has been proven to save governments money. Victims take less time and less services to recover from the trauma of crime. There are less people prosecuted where restorative justice is strong. And also there's less people in prison when restorative justice is operating effectively. So it can save money, but it's not a cheap option. Governments need to be prepared to invest considerably in order to get those benefits and to save money in the long term. Already public awareness has been mentioned, and this is critical. We need the public to understand what restorative justice justice is and to appreciate the benefits it has to society. But also there's a huge piece of work to be done in informing and educating the many, many stakeholders that it takes to make a restorative justice program work. It's not an individualistic thing. It requires cooperation and collaboration. Judges, prosecutors, lawyers, the police, local communities, NGOs. So a real communication strategy needs to be in place to grow restorative justice. Maybe for me, most importantly, is quality of practice. Certainly my research would demonstrate that the higher the quality of the practice, the better outcomes you can expect. So you need to employ good people. You need to decide, are they going to be full-time doing restorative justice, or will it be one of their duties amongst others? Or will they be volunteers? There are many different models for appointing people. But whatever choice a country makes, what is essential is competence. High quality trainers by good, high quality training by good trainers, and also the support and supervision of managers who understand the nature and benefits of restorative justice. And as Jamie has already said, the UNODC will be publishing a curriculum of training to support the handbook. And information and quality assurance systems are essential to monitor, evaluate, review, improve, continuously practice, and innovate. Finally, research. I would highly recommend that local countries invest in good independent research, again, to innovate and improve and understand and deepen practice, but also to develop their own national model for restorative justice. Because unfortunately, a lot of the research comes from Western countries, and it will be interesting as restorative justice spreads to other countries that local researchers can really develop local practices that fit the culture of the country, the traditional indigenous practices, and the institutional arrangements. And this will be an exciting time in the future. So finally, I'm here to say the European Forum for Restorative Justice is here to support you and to help you in any way it can. One of the things we benefited from is this international cooperation within Europe, sharing and reducing the isolation of restorative justice in countries. And we'd recommend regional forums throughout the world. And I know there are some already developing, and we're here to support and advise you on that. We can offer expertise on advice on law, policy, practice guidelines, research. We have a document on the values and principles of restorative justice, and very soon we will have a template for standards of practice that may be useful for some governments. And we're devising a self-assessment tool that organizations or government departments can use to sort of see where they are on the road to developing a high-quality restorative justice program, and to develop their own agenda. And finally, we do have access to a range of expert trainers and training programs that may be able to support countries throughout the world. So that's my final message. We welcome the handbook. We think it's very valuable, and the European Forum is here to support you. Thank you very much.
Thank you very much, Tim, for your presentation. Again, we heard the importance importance of the RJ program. You know, a long-term commitment of government. You know, in terms of the recognizing the benefits of RJ. You highlighted the importance of communication strategy. I think this really, you know, it is not just the people in the criminal justice system per se, but also, you know, the various stakeholders. I think that is very important. We cannot agree with you more. We at the TIJ, you know, we agree in terms of the importance of capacity building, the training, and you have highlighted that the quality of practice. So this is something is great. Now we have concluded the panel discussion part of our webinar. I want us to move right into the Q&A session, and we have so far received some questions. I am going to ask some of the questions. There is one question directly directed to Professor Yvonne Danduron. Okay, so I'm just going to quote the question, okay? Did I understand correctly that according to the study that has been recently conducted, many countries have declared that RJ as the new crime response, probably on the level of general policies, but nevertheless, RJ still remains underused because of insufficient institutionalization and implementation in the legislation? The question to Yvonne, please.
Thank you for the question. This is what I was trying to convey, and I think to various degrees, this is true of all countries. Policies basically set aspirational goals and authorizes or encourage the implementation of restorative justice. But in most instances, the aspirations are much greater than reality, and don't know that there's a country anywhere that could not benefit from some of the advice that Tim and others are providing in terms of improving systems. Yes, I think that in most countries we haven't fully institutionalized restorative justice, and for some of the reasons that panelists.
Okay. Thank you, Yvonne. I have another question. Okay, should we use restorative justice for victimless crimes, and how we could set up the meeting for these crimes? Perhaps who wants to answer this one? Perhaps Tim, please.
It's a good question, so I'll have an attempt to answer it. I think when devising a scheme of restorative justice, we need to be careful how we identify victims. There's obviously direct victims. Somebody steals something off you, you're the direct victim. But most crime, if not all crime, causes harm. And that's the key concept in restorative justice. How do you repair the harm? And usually with a little bit of imagination, you can identify the people that have been harmed by the crime, even if they haven't had a direct relationship with that crime. We have some experience in Northern Ireland of that, of sort of, crimes against corporate property, drugs, some motoring offences. But usually you can say, well, what is the ripple effect of the harm and who has been affected? Sometimes it's the family of the perpetrator of the harm that has been detrimentally affected. And then you can have something like a family group conference approach. But we've had other situations where it's been a crime against the community and you bring in representatives from the community, which really goes back to a lot of indigenous forms of justice where there's a community circle of people who both want to express their disapproval of the person's behavior, but also want to offer support to that person to sort themselves out and change their ways. So I think we should be creative and imaginative in how we apply restorative justice to local circumstances.
Yes, certainly. Thank you, Tim, for that. Again, I mean, this is a very important question on the victimless crime. We're talking about the importance of community. I mean, in many cases, I think I recall during the discussion of the expert group in Bangkok last year, it was the first time that we started to talk about RJ within the context of transitional justice. So basically, that's quite pertinent. I have one question that I would like to ask can restorative justice be equated to alternative dispute resolution mechanism in some jurisdictions? Perhaps I invite Mary Lou to perhaps take this question.
Sure. Alternative dispute resolution is a field that has been in existence for decades also, and certainly in a civil context often, or in a family law context. And certainly the model of meetings have translated into restorative processes. I would say, yes, there's a lot of similarities, that the training and the effectiveness of a good facilitator can make a huge difference. But the difference, I guess, that I would observe with a restorative justice process is that it is very much grounded in principles that are broader and try to be more holistic, I think, than just looking at a single dispute between parties. So yes, there's a lot to be learned from the alternate dispute processes, mediation. So victim-offender mediation is a process that has that is in some ways very similar, but that there's value added, I guess, and that with a restorative process, because it's grounded in principles, and that the key factor, I think, that's different is that while there are, we just talked about the different configurations that can be in existence. Traditionally, we talk about harm being done to the person who caused the harm, the victim, as well as the community. And so again, there's the opportunity for a more holistic attending to the harm done. Thanks.
Very good. Thank you, Mary Lou. I think we are almost out of time, but I think perhaps just maybe one last question, okay? And perhaps I could direct this to Jamie. This is more on the international side of things. We have a question. What can the UN bodies and institutions and the UN affiliated regional organizations like UNODC in Latin America do to support an effective implementation of restorative justice, in particular in the Southern Hemisphere? Can they come with a common vision and strategy? Perhaps Jamie can answer this.
Thank you for that question. It's a really great question. UN-affiliated bodies, including other agencies and PNIs, and also other CSOs that are active in the field of restorative justice, play an enormously influential and crucial role in the objective of promoting restorative justice in a proper way. And in addition to being a technical assistance provider in restorative justice, it also serves as a great source of a wide range of expertise in all areas that Tim has mentioned before, in mobilizing the entire justice system to realize and incorporate the values of restorative justice in their programs and implementation, and also in terms of giving legislative and policy advice, technical training opportunities, and in providing expertise in monitoring, evaluation, and innovative approaches that can happen in restorative justice. So I'd like to really, once again, thank all the PNIs and CSOs that are part of the panel today, and also to invite all those affiliated bodies and CSOs to reach out to us and to foster and also engage in more partnerships in areas where we can collaborate, especially in terms of regional presence, because as many panelists have mentioned, raising awareness on the benefits and proper use of restorative justice, we cannot do it alone, and it has to be done in in partnerships with organizations that are working in the field of restorative justice.
Okay, thank you very much, Jamie. I'm afraid that's all the time that we can have for the Q&A, and I do apologize for participants whose questions have not been answered. But I think that this, this conversation, I think we have generated quite a lot of interest, on not only on the handbook but also the different aspects. Again, I just want to take this opportunity to just to show everybody. That's basically the handbook that's been going to show. But also because I thought about what Tim said earlier about the fact that, I think he put it very nicely. Restorative justice is something that has to be nurtured, like you're talking about planting the seed, growing the tree. Here we go on the cover of this handbook. But that's exactly what I would say that this conversation that we're having at the launch webinar is, in fact, sort of a seed planting exercise, that we can, galvanize interest and to try to think collectively as we go forward. How can we further promote restorative justice? And also, our colleagues mentioned the point, the important point about how we look at this against the backdrop of the pandemic, but also look at this from the point of view of an opportunity, because even before the pandemic, we recognize this as an important part of promoting the SDG, which, by the way, I emphasize is the main theme of the Crime Congress, that the 14th Crime Congress. So I think with the launch of the handbook and the interest, and we've heard, especially like the last question that was raised about the role of regional organizations, I think that there is, increasing interest in this field. More needs to be done in terms of, promoting knowledge and training and capacity building. The European Forum, and you can count the TIJ also. We are keen, we are ready, and we're finalizing this research as a way to inform, what should be a policy going forward. So with that, final thoughts, I would like to conclude the webinar. Before I conclude, I was informed to say this. After the webinar, a link to the satisfaction survey will be sent to all participants via email. So please check your email and perhaps take a moment to fill out the survey. And your feedback will be very beneficial in helping us improve the quality of future events, just like Tim said, improving the quality of practice. Okay, with that, ladies and gentlemen, I would like to take this opportunity to thank all our distinguished panelists, all of them, and in participating in this exercise, and particularly the UNODC for taking the lead and initiating this. And that's it. Thank you very much. Thank you all. Okay, bye-bye.